Hi, everyone. Judge Andrew Napolitano here for Judging Freedom. Today is Wednesday, February 15, 2023. It's about 3:40 in the afternoon here on the East Coast of the United States. I just finished a very, very hot 30-minute interview with Colonel Doug Macgregor, at which more of you were watching live and more of you were commenting in real time than we've ever had before. No matter when you're watching this, you can pick up that interview with Colonel Macgregor about the destruction of the Nord Stream pipeline, the so-called balloon that they shot down over the ocean from North Carolina, and the state of affairs in Ukraine today. You'll find a great deal of enlightenment. But today's hot topics are: the Justice Department is trying to force Donald Trump's former lawyers, in two cases still his lawyers, to testify against him before a federal grand jury. Well, whatever happened to the attorney-client privilege? When I went to law school, way back when, the attorney-client privilege was absolute. And unless your client told you, I'm going to shoot someone, you had to keep it secret. But if your client said, I shot someone, or your client said, I robbed a bank, what should I do with the money? Can you help me hide it? There are certain things that there are no secrets about. So the American Bar Association, which pretty much regulates these things, issued some new regulations, and then they were adopted by the courts in America that regulate the legal profession. Usually the legal profession in each state is represented by the highest state court. So usually called the Supreme Court of fill in the blank. The Supreme Court of New Jersey, for example, regulates the legal profession. They, the Supreme Court justices, adopted the new American Bar Association rule. In some states, the courts that adopt these rules have different names. In New York State, for example, it's the Supreme Court of New York Appellate Division adopts these rules. But in most states, it's the state court of last resort, and it has the word Supreme Court in it. What is the rule? Well, the rule says that there is no privilege if the lawyer and the client together participated in an act of deception. So if Donald Trump lies to his lawyer and says, tell the DOJ they have all the classified documents that I took with me when I left the White House, and the lawyer tells that to the DOJ, and it's not true, even though the lawyer believed it was true, that is an act of deception perpetrated by the lawyer and the client. And so there is no attorney-client privilege. If the lawyer knowingly lied to the DOJ, then the lawyer has committed a crime. And so what's called the crime fraud exception defeats the attorney-client privilege. In that case, the lawyer would have to stop representing the client because the lawyer is a defendant in a companion case, and the lawyer would have to get his or her own counsel. So when the DOJ has subpoenaed Trump's lawyers, and they have, and they've shown up, they've said attorney-client privilege, and then they go before a federal judge supervising the grand jury, and the federal judge decides whether or not there is truly a privilege. If the DOJ makes out a case for the crime fraud exception, either the client induced the lawyer to commit an act of fraud, or the client and the lawyer knowingly together committed a crime, then there is no attorney-client privilege. As I speak, literally, at 3:45 Eastern time, this afternoon in Washington, D.C., this is being argued before a federal judge, and you will probably see her ruling in a day or so. So the attorney-client privilege is not absolute, and attorneys can get themselves in a lot of trouble when they do whatever the client wants them to do. In January, for the first time since 9/11, I didn't know about this. It wasn't in any of the major news. The FAA grounded every plane in the United States. Did you know that? Now, this is not that huge mess that occurred around Christmas time with Southwest Airlines, where people were sleeping in airports for 4 or 5 days at a time. This was later in January. Every plane in the United States was grounded for 2 hours, every single plane. And the reason for the grounding was an FAA outside contractor had damaged some FAA software, and the FAA could not, through control towers, tell pilots when to take off and when to leave. It couldn't communicate with them, and it couldn't warn them of you're getting too close to another plane. So they grounded every plane. We just learned about this the other day. Why is this important? Well, it's important because it's an enormous effect on the economy when the government does this, and it didn't tell us until a month later. Here we are in the middle of February. Today's February 15th. It's also important because the excuse they gave was the FAA, the government, uses old computers and old technology and old software. Well, how about private enterprise doing this where they would compete with each other? How about ABC Corp at JFK Airport and XYZ Corp at LAX Airport? And how about they compete? And that costs the price to go down and the services to improve. But when big, fat, lazy federal government runs every airport in the country and then discovers after a near tragedy that its computers and its technology and its software are outdated, how do you expect them to find that if they don't have a competitor breathing down their back? I've been arguing for years the problem with government providing services in this country is that most of those services should be provided by private enterprise, which will react to competition, which will do the right thing in order to get more clients. What do you do to get more clients? You lower the cost and you improve the services. Government has no interest in lowering the cost, and no interest in improving the services. Look for more of these shutdowns. One of you has asked a very interesting question. The TikTok folks ask a lot of questions. I'll read it verbatim. In your call for transparency from the government, that we should know what they know, how should sensitive national security info be handled and distributed? It shouldn't. Whatever the government knows, we know. How can the employee know more about the business than the employer? In my world, the government will be a lot smaller, as I just argued. And much of what it does by way of performing services would be done by private enterprise for the reasons I just articulated. But the smaller government works for us. Whatever it owns, you can own. Whatever it knows, you should know. To see Marco Rubio walk out of a secret briefing from the CIA with a pained, exhausted look on his face is absurd. And I'm not critical of Senator Rubio. I happen to like him a lot, even though I disagree with him on many things. But why should our representatives know things that we don't know, that they can keep to themselves and use to increase the budgets of the Defense Department when they don't need it, but they've been threatened or because they know a secret, or increase the budgets of the intelligence community because they've been threatened or they know a secret? There should be no secrets when it comes to government. What the government owns, you should be able to purchase. And what the government knows, you should know first. More as we get it. Judge Napolitano for Judging Freedom.